Brian, just signal when you're ready.
Yeah, I think we could start. Let me see.
Very good. Welcome everyone to the California Law Revision hearing for June 22nd. David Heebner filling in as chair in the absence of our chair. Brian, would you call the roll?
Yes, in alphabetical order, Commissioner Carrillo, not present. Commissioner Carrion,
Present.
Commissioner Cubas,
Present.
Commissioner Heebner,
Present.
Commissioner Jenkins,
Here.
Commissioner Kalra is not present. Commissioner King,
Here.
Commissioner McAllister,
Present.
Commissioner Roth is not present. Commissioner Simpson,
Here.
we have a quorum.
Excellent. Thank you, Brian. Our first agenda item is on the antitrust law study. We're honored to have with us Professor Alison Jones of King's College London. Professor, we turn the floor over to you for your presentation on European Union competition law. Before you start, would you prefer that we hold questions until the end, or will you be happy to entertain questions from commissioners as you go along?
Please just stop me and ask as we go along if that's easier. That's absolutely fine.
Very good. Thank you.
Thank you. Okay. Well, thank you very much for inviting me to make this presentation. So I'm going to try in the space of the next hour and a half or so to give you an overview of the European competition laws. So what I thought I would do is try and introduce the main provisions, and during the course of the presentation really to try and highlight the core similarities and differences to the federal US federal antitrust laws, so to sort of situate them slightly that way, because we can't look at the whole system in detail in that much detail in an hour and a half. So I thought in terms of sort of highlighting similarities and differences, that what I would focus on is the enforcement structure, and particularly the public enforcement structure at the EU level, so enforcement by the European Commission, and on the substantive appraisal under the EU competition law rules. So really how we try and distinguish anti-competitive conduct prohibited by the competition law rules from other sort of beneficial, pro-competitive or competitively neutral conduct. And I thought just at the as a final note, I might talk very, very briefly about the Digital Markets Act and why in Europe we have decided the European Union has decided that they need new rules which are aimed to ensure that contestable and fair markets exist in the digital sector. So it's just a highlight, an overview of what I'm aiming to say in this presentation. So just to start with an overview of what the rules are, just to mention, first of all, that although we know that competition law now is a truly global regulatory exercise, the EU regime is one of the older regimes, of course, not nearly as old as the US federal rules, but dating back to the 1890, but the rules that we're talking about today date from 1957, when they were incorporated in what was then the European Economic Community treaties. So that treaty context still remains important. The treaties have been amended and developed, and we've moved from a European Economic Community to the European Union over time, but the competition law rules, well, at least Articles 101 and 102 we'll talk about, are situated on within the Treaty on the Functioning of the European Union, which is the treaty which sets out the more detailed provisions of substantive law that apply in the European Union. So unlike the Sherman Act, for example, we don't have standalone, the EU does not have standalone competition law statute. They are situated within this treaty and with as part of this European Union, which has a number of broader aims and objectives. In particular, of course, the core objective of creating a single or an internal market within the European Union. So I think just to highlight this fact and to say that one of the main aims of the European Union is to establish the internal market, where you'll have sustainable development and a highly competitive and social market economy, and that these competition law rules are designed to ensure the proper functioning of that internal market, and that competition within it is not distorted. Because these are EU competition laws situated in the EU treaties, then there are important roles for the EU institutions, not only the judicial institutions, but non-judicial institutes within that, within the framework. So I've highlighted 3 points here. First of all is the European Commission, which plays the role as enforcer of the competition laws at the EU level. It's also got another role as part of the legislative process, which we'll come back to in the moment. Then we have the European courts, which are charged with responsibility for interpreting the treaties. So they ultimately decide how the competition law rules are interpreted, and they also have the ability to review the legality of acts and adopted by the institutions. And that's very important, because we're going to see in a moment, when I talk more about enforcement, that the European Commission actually acts as an integrated decision taker, adopting its own decisions in this area, which can then be subject to review by the court. So I'll come back to that point in a moment. And then there is also the EU legislative process, which means that the autonomous EU institutions are able to adopt legislation through regulations or directives, which to flesh out the principles of the treaty. And the Commission usually plays a role of proposing legislation, which is then tends to be adopted by the Council, the representatives of the member states, and the European Parliament. So those EU institutions have an important role in the context of the EU competition law rules. So what are those rules? Well, like many other systems of competition law, including the US federal laws, they're really sort of founded they really stand on 3 main pillars. So most competition law systems will have rules which are designed to prohibit restrictive agreements or other collusive activities between independent firms. That's Section 1 of the Sherman Act in the US. They usually also have provisions which are designed to control the conduct of firms with significant market power, monopoly power in Section 2 of the Sherman Act, or dominant position in the EU, and then rules which prohibit mergers, which will kind of lessen or impede competition on the market. That's Section 7 of the Clayton Act. So those are set out. We have these 3 pillars in the EU. Our prohibition of anti-competitive agreements is set out in what is now Article 101 of the Treaty on the Functioning of the European Union. The rules dealing with abuse of dominant position held by a dominant firm are set out in Article 102 of the Treaty on the Functioning of the European Union. And the original treaty did not incorporate merger control provisions. The European Commission recognized from very early on that this was a big gap in its powers. It did its best to try and use 102 and 101 to exercise some form of merger control, but what it really wanted was specific EU rules controlling mergers. The Commission could propose that legislation, but it had to be adopted at that time by the Council, the member states, who weren't, for a while, took some persuasion to pass that control to the European Union level. That was done in 1990 originally. And so now the merger control rules are set out not in the treaty itself, but in a council regulation, which deals with merger control. So we have those three pillars, two of them set out in the treaty themselves, and the third one, the merger control rules, which are set out in a council regulation, which was adopted by the EU institutions. Just to note, and I'm not going to say any more about those rules in this presentation, there are also some rules which are directed not just at undertakings, that's entities engaged in economic activity, very often private firms, but there are some rules which are directed at member states as well to stop them engaging in conduct which will distort competition through perhaps giving state aid to firms or having in place rules which confirm special or exclusive rights on firms. So those are the main provisions, and we're going to talk a little bit more about those during the course of the provisions. So we've got the three main pillars: Article 101 for agreements, 102 for abuse of dominant position, and then the merger regulation, which deals with mergers which would significantly impede effective competition on the market. So just before we look at the substantive provisions, just a few words about how these rules are enforced. And again, I think that just to highlight that the enforcement system is really quite different to that which exists in the US. Obviously, every competition law system needs to have a good enforcement system. It's only through enforcement that we begin to see how the rules should be applied and interpreted. And if you look at the wordings of 101 and 102 in the merger regulation themselves, I'm going to put them up in a moment, you'll see that a bit like the Sherman Act, they're fairly skeletal provisions. They don't define core terms like restriction of competition, abuse, what a dominant position is. So it's only through the jurisprudence and the bringing of cases that we begin to see how these rules apply and what their provisions mean. And that is obviously also how over time law gets clarified and developed. But of course, we also need effective enforcement to ensure that infringements don't occur and are brought to an end, that firms that engage in prohibited conduct might in certain circumstances be punished, but ultimately might be deterred from committing future infringements. And perhaps we also want to ensure that victims of antitrust violations can get some compensation. So this is the enforcement system. Just sorry, it's a very busy slide, but I'll explain it in more detail. For the enforcements of Articles 101 and 102, we've got a slightly different enforcement structure for the merger regulation. So basically we have public enforcement and private enforcement, and we have enforcement at the EU level and at the national level. So public enforcement at the EU level is, as I've already mentioned, carried out by the European Commission, and there's a particular Directorate General, DG Comp, we call it the Directorate General for Competition, that is responsible for enforcing those rules. And they have powers delegated to them by an EU regulation to enforce those rules. And I'm going to talk a little bit more about those in a moment. But what we'll see is that it is an integrated decision maker. It adopts its own decisions, so it conducts its own investigations and ultimately decides whether or not infringement has occurred. It's got power to impose penalties for infringement, and the courts only get involved if there are appeals from those decisions. At the national level, because these rules have direct effect and can apply in the member states, there is public enforcement by national competition authorities who can apply not only their national competition laws, but also the EU competition laws. And then you could have private enforcement in the national courts in the same way as you do in the US, have private enforcement for damages actions or injunctions by private litigators, and all that private enforcement occurs in the national courts of the member states. So a little bit more about how the Commission decides, and I think this is sort of important to understand perhaps some of the cases that we'll talk about later, particularly in the context of 102. So unlike the Department of Justice, for example, it does not have to prove its case before an independent tribunal or court. It's not a judicial model. Regulation 1/2002 means that it can act as an integrated decision maker, performing investigative, prosecutorial and adjudicative functions. So it decides whether to investigate, whether to initiate proceedings, whether an infringement is incurred, and the sanctions to be imposed. So it doesn't have to prove that before the court, but if a party or even a third party in certain circumstances is unhappy with the decision, they may seek judicial review before the EU courts. And at first instance, it goes to the General Court, and then there are appeals on point of law to the Court of Justice. So it has got the Commission's got its own process where it conducts preliminary investigations, then it decides whether or not to initiate more formal proceedings, then it decides, and then there's the possibility for judicial review. So it can investigate on its own initiative, following a complaint or perhaps a leniency application or a whistleblower coming to them. It's got fact-finding powers conferred on it under Regulation 1. And because it's an integrated decision maker, it has to be very mindful of rights of defense and due process, and to make sure that its internal procedures sufficiently respect those principles. If it wants to launch formal proceedings, it issues something called a statement of objections, which is what it's recently done in relation to Google and AdTech. It's just issued a statement of objections there, where it essentially sets out its case against the investigated firm, suspected infringement, possible remedy, etc. And then there is a whole process of state of play meetings, etc., right to be heard before the Commission can adopt its decision. And then it can adopt, at the end of that process, it can do a number of different things. It could decide not to adopt a decision at all, but it could adopt an infringement decision under Article 7 of Regulation 1/2003. And under that provision, it's got power to impose fines of up to 10% of the worldwide turnover of the undertakings involved. And we will see that there are some very significant fines. The fines imposed on Google in 3 decisions amounted to almost sort of 8 million euros. It can also impose, and it will also issue a cease and desist order, saying you need to bring the infringement to an end. And it's also got powers to impose remedies, whether they're behavioral, to behave in a certain way, or possibly even structural, to ensure that the infringement is brought to the end, and so that compliance with the rules is then restored. So although in theory it's got these powers at the end of a proceeding, Article 101 or 102 proceedings, to impose structural remedies, the use of these remedies is policed quite closely by the courts, which will insist that any remedies imposed are proportionate and the least restrictive possible, and that if it wants to impose structural remedies, there's not a less restrictive behavioral remedy which might be available. So we haven't seen to date an awful lot of use of these structural remedies, at least in the context of infringement decisions. The Commission does also have the power to adopt these decisions called commitments decisions. And the way that these work is that the Commission effectively says it won't adopt a final decision if the firm or firms agree to change their behavior, and the decision renders binding undertakings on those parties to behave in a certain way. So where we have seen structural solutions, they have more often been in the context of commitments decisions, because they're sort of more negotiated and agreed than in that might be the case in the context of a full infringement decision. And I think certainly in the Google shopping case, the Commission and the parties did discuss commitments in the end, for quite an amount of time, but in the end, the Commission wasn't happy with them and moved forward to an infringement decision. It's also got powers to impose interim measures, but these have not really been exercised very frequently in practice. So that's the administrative model that the Commission follows. We could talk for a long time about the pros and cons of an administrative against a judicial model. But one of the debates that sort of reached a crescendo about sort of 10 years ago in the European Union was this model actually compatible with the European Union's own Charter on Fundamental Rights, which effectively says that firms who are going to get these quasi-criminal fines imposed at them on the end of the proceedings need to have the right to a fair trial before an independent and impartial tribunal. So there are some people who have argued they need to move to a judicial model, but the case law in this area seems to suggest that the integrated agency model is okay as long as the decision-taking proceedings, have sufficiently strong procedural guarantees within them, and there is sufficiently rigorous judicial review at the end of the process by a body that's got jurisdiction to look at questions of fact and law and to challenge and quash decisions. And certainly that the European Court's view is these powers do exist. The General Court has got unlimited jurisdiction to cancel and reduce fines, but it can also review the legality of decisions on the 4 grounds that I've set out in this slide. One of them is infringement of essential procedural requirement. So if they have not respected rights of defense, that would be a ground to annul the decision, or if they've misapplied the treaties or the rule of law. So if on scrutiny of the factual basis, the court is not does not think that the Commission has established what it says it's established in its infringement decision, that would also be grounds for annulment. So that's the basic enforcement framework for 101 and 102. We've got a slightly different setup for the European Union merger control rules, which are set out in a council regulation. And so basically, it is only the European Commission that can apply the merger control rules set out in the merger regulation. They cannot be applied by national courts or national competition authorities. So the idea of the merger regulation is that if you have got a merger which has got an EU dimension or then you notify it to the European Commission, you suspend the transaction, you wait until the Commission decides whether or not you can go ahead with the merger, and you get a one-stop exclusive appraisal by the European Commission for the whole of European Union under the European merger regulation. And it's only if the merger does not have an EU dimension that the merger can be appraised at the national law, not under the merger control rules, but under their own national merger control rules. So the idea is that a merger should either be looked at by the European Commission, or it can be looked at by one or more of the member states under their national merger control rules, but not both. Although nothing is ever that simple, there are some exceptions to those general rules. So that's a gross oversimplification, but just a sort of summary, and to make the point, it's a little bit different enforcement structure to 101 or 102. But when the Commission is looking at the mergers, it is also an administrative model. So it ultimately investigates and decides whether or not the merger is or is not compatible with the internal market, whether it should be prohibited, whether it should be permitted, or whether it should only be permitted subject to commitments, subject to slight changes in the transaction or sort of promises as to how you might behave in the future. So, and the Commission has to make a decision either to clear it or not to clear it. So it can't just let a waiting period expire and not challenge it. It's got to adopt a decision in relation to a merger that is notified to it. So that is the basic enforcement framework. So if you don't have any questions on that, I'll just talk very quickly now about objectives. And obviously, I'm sure you've been already talking about federal antitrust laws, and you know that this is a very, very live subject, which is very complicated. And again, we could talk about for a long time. But I'm just going to deal with this very quickly and make three main points. So the first one is, like the Sherman Act itself and the Trading Act, it's not very clear statement in the law itself what the objectives are. We've got fairly skeletal provisions where core concepts such as restriction of competition, abuse, dominant position, significant impediment to effective competition aren't defined. So although there are some examples in the legislation themselves about the type of conduct that could constitute a restriction of competition or an abuse, really the meaning of those words has only been elucidated through the cases by the EU courts, who are charged with responsibility for interpreting the treaty. But of course, because the Commission acts as an integrated decision taker through an administrative model, it has actually had the ability to have quite a powerful influence on the development of the law, because it's in many of the cases, it's actually its interpretation of the law which is in question and being considered by the courts on appeal. So over the last 20 years or so, there's been a modernization process in the EU, and there have been a growing consensus that or at least a main goal of the competition law rules should be the consumer welfare one, and that had been sort of developing in it and emerging, but as in other jurisdictions, really that consensus is being increasingly challenged and questioned, and certainly within the EU, the whole question might be a little bit more complex because of the situation of the competition law rules within this treaty structure, which is about many things: the social market economy, about ensuring sustainable development and environmental protection, etc. So there is a question of whether or not you can really completely divorce competition law from those other goals and aims, and that's a sort of ongoing debate. But in general, the Commission's view still seems to be no, it's principally a consumer welfare objective, but it has been thinking quite hard in recent years and months about environmental issues and the way that competition law and the European Union's Green Deal and environmental policies can work together, and whether or not, for example, vigorous competition law enforcement which benefits consumers and consumer welfare will also contribute to other EU goals such as fairness and equality, and plurality and democracy. So there's an ongoing debate, and I'll come back to some of those particularly and maybe the sustainability issue in briefly later as we go along. So obviously these objectives are really crucial for us to know what we're doing and how these provisions, what a restriction of competition means, what an abuse of a dominant position is, and how we can craft legal tests to try and identify anti-competitive conduct and distinguish them from pro-competitive or competitively neutral conduct. Or as Justice Breyer put it in was in Legion, how do we separate beneficial sheep from antitrust goats? But I think what we'll see in the EU, as particularly compared with the US, and especially when we especially in relation to use of dominant position, but also in relation to agreements, is that in general, I think our rules are a bit more skeptical about the certain types of behavior, more willing to condemn them, and haven't set quite such high bars for plaintiffs or claimants to overcome, to establish anti-competitive or abusive conduct. So moving on, then, there are no questions on the enforcement structure and the treaties. I'll move on to have a closer look at Article 101, the prohibition of anti-competitive agreements. So but that's just the text of the treaty. So you can see my point here that it's fairly skeletal, refers to agreements which have as their object or effect the restriction of competition, a few examples of what those agreements might look like, but no elaborate definition of core terms like undertaking, decision, etc. So that's all been left for interpretation. So one first thing to note is that unlike section 1, which just prohibits contracts in unreasonable restraint of trade, Article 101 is divided, the substantive appraisal is divided into 2 parts. So we've got a main prohibition, which is set out in Article 101, paragraph 1, which prohibits agreements which restrict competition, whether by object or effect. And then, even if the agreement does restrict competition, there is a legal exception for agreements which meet the 4 conditions which are set out here in Article 1013. So that gives, because the burden is on the claimant to establish the infringement of Article 1011, that gives the defendant or the parties to the agreement the opportunity then to claim that even though their agreement is restrictive of competition, it produces countervailing benefits, and that all 4 of those conditions of 1013 are satisfied. So not only does it produce benefits, those benefits will be passed on to consumers. The restricted provisions are indispensable to achieve those benefits, and there's no elimination of competition in the market. So they're quite onerous restrictions. So a few points to make about the way Article 1 it applies is that it's for the claimant then at first instance to establish anti-competitive effects, as it would be in the Section 1 Sherman Act case. And they've got 2 main ways of doing that. First of all is that they can simply say that this agreement is assumed to restrict competition. Its main objective is to restrict competition. So its object is to restrict competition. And in that situation, no demonstration of restrictive effects is required. They are assumed. It's assumed to produce restrictive effects. And that agreement will then be prohibited unless it's justified, the parties can justify it under Article 1013. So there's no exact equivalent of a per se rule in the EU, because in theory, even agreements assumed to restrict competition can be defended under 1013. But in practice, it tends to be quite difficult to justify those types of agreements of 1013. So it comes closer to the per se rule in practice than it. So the difference might be more theoretical than real in many cases. Where the objective of the agreement is not to restrict competition, then the claimant has got to demonstrate restrictive effects, which could be actual restrictive effects or more likely potential ones inferred from the market circumstances. So, and similarly, there are 2 main ways from benefiting for the parties to benefit from 1013. So one way is actually the second one I've put on this slide, is for them to individually explain why their agreement satisfies those 4 conditions, how it improves efficiency, how consumers are going to get a fair benefit, why the restrictions are indispensable to achieve those efficiencies, and that they've got no possibility of eliminating competition. And as I've already mentioned, those are pretty onerous conditions. But in some circumstances, an easier way to satisfy the conditions of 1013 might be to satisfy the conditions of what are known as block exemption regulations. And these are EU legislation regulations usually adopted by the Commission under delegated authority by the Council, which grant exemptions to categories of agreement which meet certain conditions. And because they're regulations, they have the force of law. So if your agreement satisfies those conditions, it is automatically exempted from the Article 101 prohibition. And there are a number of block exemption regulations which apply for a number of vertical agreements, for technology transfer or IP licensing agreements, and for certain horizontal cooperation agreements, research and development and specialization agreements. So these regulations, as I say, exist for these different categories of agreements, and usually to benefit from them, the parties have to ensure that their agreements on their market circumstances comply with certain conditions. So they're usually conditional on certain market share thresholds being satisfied. The parties' market shares don't exceed certain levels, which is used as a little bit of a proxy, as an idea for that they haven't got a level of market power, which would be worrying, and that the agreement doesn't contain any particularly severe restraints within them. And there's usually a number of other conditions. So they're a bit more complex than that, but that's the basic way that they work. So last year, the Commission adopted a new block exemption for vertical agreements, which covers vertical agreements between non-competitors, a supplier and a wholesaler or retailer, so long as none of the parties to the agreement exceed certain market share thresholds, which are 30%, and the agreement doesn't contain any particularly severe restraints, and those restraints are listed in the regulation themselves. So, for example, in the context of vertical agreements, you cannot incorporate resale price maintenance within it. Then the block exemption doesn't apply to you. So the Commission thinks this is treats this as a particularly restrictive provision, which can't be authorized under the block exemption. And in fact, there's no case where actually resale price maintenance has actually been permitted or found to be compatible with Article 101 in the EU. Other hardcore restraints include restraints on the territories into which all the customers to whom the buyers can sell their products, and also restraints which prevent the buyers from all effective use of the internet for selling their products. So the Commission has been quite concerned through the restructuring of this block exemption to try and make sure that e-commerce can develop and isn't being sort of hampered by contractual restraints in vertical agreements. And it's drawing a delicate line between the pro and anti-competitive uses of these vertical restraints. So that's an example of how one block exemption applies, the verticals one. So that's just the structure of Article 101. So I thought I'd just now make a few observations about the similarities and differences with Section 1 of the Sherman Act. So as in the US, a core priority for the European Commission is the fight against cartel activity. So Article 101 is obviously the core provision which allows the Commission to prohibit collusive conduct between firms which restricts competition through fixing prices, sharing markets, restricting output, rigging bids, etc. And this is a major priority of the Commission to try and prohibit this conduct and to, through its prohibition decisions, to sort of deter other firms from engaging in this conduct. So this cartels are clearly prohibited under Article 101. They restrict competition by object. It's very unlikely that there will be any efficiency defense that can be raised under 101(3). And if the Commission finds a cartel, it will impose significant corporate fines on those that have been involved. So the issue in the EU is not so much are these cartels prohibited? The issue is how do you detect them, prevent and deter them? And at the EU level, the main sanction, the main penalty at the end is corporate fines. There is no EU criminal law as such, that it's not a criminal offence at the EU level, although it is in some member states. And so if there's an EU investigation, the main concerns for those investigated are corporate fines, and then most likely now follow on private damages actions. If the cartel gets investigated at the member state level, then there might be some sanctions for individuals as well, through individual fines or even imprisonment in some member states. So another, and I think probably another main difference between Article 101 and Section 1 is that I think we do really have more detailed and sort of hands-on regimes covering the sort of minutiae of how other non-cartel agreements should be appraised under Article 101. So there's fairly extensive use of presumptions of illegality for certain types of conduct, for example, resale price maintenance, which I've mentioned. This type of resale price maintenance tends to be treated as an agreement which restricts competition by object. It can't benefit from the block exemption because it's a hardcore restriction. So it can only be included in agreement if the parties are really convinced that they would have a good efficiency story to tell under 101(1)(3). There aren't really examples of that happening. So we have strong presumptions of illegality for certain types of conduct. We have presumptions of legality or safe harbors for a swathe of agreements through the block exemptions. So many vertical agreements between firms whose market shares don't exceed 30% will just be automatically assumed, if they satisfy the conditions of the block exemption, to be compatible with 101. And then where these presumptions of legality and illegality don't apply, the Commission produces fairly detailed guidance, because there's fairly limited case law on how the Article 101 is applied outside of those scenarios. And the Commission has very, very detailed guidance stretching to hundreds of pages as to how you analyze vertical agreements under the block exemption, but where the block exemption doesn't apply, and the same in relation to horizontal cooperation agreement. So it has just been, last year it updated the regime governing vertical agreements, and it has just on the 1st of June of this year updated the horizontal cooperation regime. So there are 2 new block exemptions now for research and development and specialization agreements. And then there are very lengthy guidelines on how other horizontal cooperation agreements are analyzed. And that document has a whole chapter dedicated to the question of how you deal with sustainability agreements, because there's been a big head of steam behind the argument that the competition law rules in this area are too strict, that there are market and regulatory failures, which means that it's very difficult for firms individually to pursue sustainability goals, and that sometimes they need to work together to try and make their products or their services more environmentally friendly, and that there should be a bit more leeway and recognition that that cooperation can be good when regulation perhaps is not sort of working fast enough. And the Commission and a couple of the sticking points have been, how do you fold those sustainability benefits into the Article 101 framework? Are they cognizable benefits that can be taken into account under 101.3? Who are the consumers who've got to benefit? What about the consumers purchasing the products? They might be paying more, but can we take into account out of market benefits, the benefits to society, to citizens more generally, through perhaps producing more sustainable products, etc. So the Commission's been sort of wrestling with all that, and so have a number of the competition authorities at the member states. So there's been a robust debate, and that the Commission's view is now reflected in that that document. And I think I've pretty much already spoken to this slide about the verticals regime, but I think just to point out that since Sylvania and Legion, many agreements, vertical agreements in the US are now analysed under the fuller rule of reason analysis and are quite hard to challenge for claimants. We still do have quite strict rules against certain types of vertical restraints in the EU, even with firms that don't have significant degrees of market power. In market shares under 30%, you still can't put resale pricing incidents into your agreements generally, or it's a risky thing to do. So that was the main points I wanted to make about Article 101. So if there are no questions, I'll move on to have a look at Article 102, which is our provision which prohibits abuse of a dominant position. And again, I've put the wording of 102 onto the slide here. So essentially what it says is that a firm with a dominant position that commits an abuse of that dominant position, it is prohibited, that an abuse of that dominant position is prohibited as incompatible with the internal market. And it gives some examples of abuses here, and I'll come back to that in a moment. Unlike 101, there is no 102 paragraph 3, if you like, which says that even abusive conduct can be justified, providing a legal exception for it. Nonetheless, despite that absence, the Court of Justice in its cases has made it clear that dominant firms are entitled to raise justifications for their behaviour. And if you like, they've pretty much read a 102.3 defence into 102. Just in terms of the way that cases are prioritised in the same way as under Article 101, what you tend to see is the competition agencies focusing their resources on the more serious types of infringement, where very often the firms don't have very strong defences. So we don't see many examples of these defences being used successfully, but it is there through the case law. So,
Professor?
Yes, of course.
Professor, do you, apologies for interrupting, but on the prior slide, do you have an example of what would be considered objective necessity on a technical ground? Does that refer to the content of the product?
Yes, so again, there's no examples of it being successfully used, but you might say, I am going to tie the sale of nails to the sale of my nail gun because I want to make sure that my nail gun is safe and that inferior nails aren't used, and that the product might not be safe. So that might be a sort of theoretical type of argument, and that argument was raised in a case called Hilti involving nail guns. It wasn't successful on the facts. But yeah, that type of argument
So it doesn't necessarily refer to the content of technology. It's not a carve out for a particular sector.
No, no, no. Yeah, it's more a different type of justification to the type that we've been talking about into relation to 101 and a sort of an efficiency rationale for what you're doing based on, you know, you're hoping to improve production or technical development in some way through your doing. So it's sort of differentiating it in that way.
Thank you.
Can I ask that the commissioners mute themselves? There's one commissioner, we're getting feedback. Thank you.
So thank you. So like Section 2 of the Sherman Act, this is the EU provision which focuses principally on the unilateral conduct of a single firm, but only where they have a significant degree of market power, and that is referred to as a dominant position in the EU as distinguished from monopoly power in the US. So this is the provision which is designed to constrain the behavior of firms whose behavior isn't constrained in the same way as most other firms operating in the market by competitors, substitutes, buyers, etc. Just a few differences to note between Article 102 and Section 2. There is no offence of attempted acquisition of a dominant position in the EU, so or of attempt to monopolize a market. It only applies if a firm already has a dominant position. So you have to show they have a dominant position and then that there's been an abuse of that dominant position. But I think one important point to note is that at the EU, they are concerned at much lower levels of market power about a firm's behavior than they are in the US. So as I understand it, in the US under Section 2, you're really talking about market shares of around 70%, 60, high 60s, 70% before you need to start worrying about monopoly power. In the EU, dominance, firms have been found dominant when they have market shares of around 40%. Very often they do have higher than that, but when the market shares are getting up to 50%, then the case law says, well, in that case, you know, we'll start with a kind of presumption of dominance here that can obviously be rebutted, but we need to look at other factors apart from market shares. They're just one factor, but dominance can be found at lower levels. I think another
question. Yeah. In determining what the market share is that across the EU or is that in each of the member states, or how do they determine that?
Yeah, so in theory, you've got to start with a market definition, which will of course need you to decide what the relevant product market is and what the relevant geographic market is. So that will differ from case to case. So it could be a global market, or it could be an EU-wide market, or it could even be a national or even a very sort of local market. So as long as it constitutes a substantial part of the internal market, then Article 10, and there's an effect on trade between member states, then Article 102 could apply. So that's a factual question which will depending on the relevant product.
So you first have to define what the market is and where it is, and then whether
you're dominant on that market. So that's the traditional way to establish dominance, and that's what the cases say. You start with identifying the markets. I mean, there was debate about whether or not whether you should kind of still in this day and age start with that approach, but that's certainly what the case law would say. So yeah, you
Okay.
have to think about, so if you've got one of the earlier cases is called United Brands, from a case from the 1970s in the US, and the relevant question there was whether bananas was a relevant market or whether other things are within it. So you have to go through the relevant market definition, look at it from a product and a geographic perspective. Then you look at market shares, and that gives you a snapshot of who's on the market now,
Okay.
what market share the allegedly dominant firm has, how significant its competitors are, but also very particularly, are there barriers to entry into that market? Who can easily come in? Because if there are no barriers to entry into the market, then, and there are potential competitors waiting in the wings, then you could have 80% market shares and you still wouldn't be a dominant. So it's just one factor that is taken into account. But yes, it would start with an identification of the relevant market. But that has become increasingly difficult in some scenarios to identify markets, obviously.
I'll bet. Yeah. Thank you. Thank you.
So I think one other point to which is that perhaps there's no equivalent of in the US, is that the cases have consistently referred to the fact that dominant firms have a special responsibility to make sure, because they are dominant and they're in a dominant position, to ensure that they are not sort of hampering the maintenance of competition on its growth. So growth, and so recognition that the market's already fragile because of their existence. And I think how much that actually adds to the identification of abuse, I think we could debate and question. But I think it's sort of an interesting perspective which has perhaps shaped and molded the legal test for identifying abusive conduct. And I think in some of the US cases, on the contrary, you see the courts be more worried about actually hampering firms from competing vigorously in markets where competition is limited, because competition is already limited and they don't want to discourage them from aggressive competition and low pricing. So there could be different perspectives, but that this special responsibility is referred to in many of the cases. Another differentiating, at least in theory, factor is that Section 2 focus is on exclusionary conduct, the willful acquisition or maintenance of that sort of monopoly power. But Article 102, and if you actually look at the wording of 102 itself, if I can go back here, you can see it talks about imposing unfair selling prices, applying dissimilar conditions to equivalent transactions, etc. Article 102 has been held to specifically apply to exploitative conduct. So if you are dominant, one of the perks of being dominant is you can raise prices above some competitive levels and charge super competitive prices. You can also provide a pretty bad service, and your consumers don't have much choice but to stick with you. So those exploitative abuses are prohibited, in theory at least, under the treaty. And it also specifically talks about discriminatory behavior, where you apply dissimilar conditions to equivalent transactions and put one of your customers at a disadvantage vis-a-vis another. And that's a little bit closer to the secondary line price discrimination referred to in the Robinson-Patman Act in the US. So it prohibits both those types of conduct as well as exclusionary conduct. Having said that, most of the cases and the enforcement is focused on exclusionary conduct, and we don't see very many cases dealing with exploitative or purely discriminatory conduct, unless that discriminatory conduct is harming the competitive process and excluding rivals and then harming consumers. But they are there in practice, and I think one of the particular challenge, and I think in Trinco, the Court of the Supreme Court specifically said that Section 2 does not reach exploitation, that actually rather the dreams of early monopoly profits is what drives competition. So it sort of sees this as bound up with the reward for winning the competitive battle, and what you really need to focus on is conduct which is designed to make it more difficult for your rivals to compete, excluding them or raising their costs. Another difference is that, I mean, well, certainly until recently in Section 2, enforcement has generally been civil enforcement. And so no corporate fines at the end of it or individual sanctions. But in the EU, in the same way as an infringement of Article 101 and the cartel agreement can attract fines, abuse of a dominant position can also attract fines and the imposition in theory of remedies. And I think this is one of the big issues under 102 is how you actually try and design any remedies to prevent this conduct occurring going forward, which isn't easy in practice. So I'd say those are some differences to highlight. So similarities, like Section 2, it's not an offence to be dominant, it's not an offence to have monopoly power. You have to have monopoly power dominance and some unlawful conduct. The concept of abuse is an objective concept. So you don't necessarily have to have establish a subjective intention to abuse, although sometimes documentary contemporaneous documentation can be unhelpful if you're trying to show that you didn't abuse your dominant position, if you've got some documents which indicate otherwise. So really the challenge in both the US, the EU in these areas is to try and identify unlawful exclusionary behavior and to distinguish it from legitimate kind of hard-nosed competition on the merits. And I think we've seen that, as in the US, we've got a burden shifting framework. The claimant's got to establish abuse at first instance, and only if they can do that does the burden pass to the defendants to try and establish objective justification. So I think again we have quite a similar idea of what exclusionary conduct does do in the US. So what we're looking here for is really abnormal competition, methods different from that which condition normal competition, which has the effect of hindering the maintenance or degree of competition still existing in the market. So we're trying to distinguish competition on the merit, which is based on superior performance, because you're beating your competitors because you've got the best product at the lowest price, which is excluding them from the market, and conduct, which is not just based on performance and is excluding them and preventing them from entering or expanding into the markets, and thereby harming consumers because you're stopping competition develop or grow in the market, and that as a result of that, consumers of those products or services are going to pay more for their product. So the Court of Justice has been very clear, we're not here to protect smaller, sort of weaker, less efficient competitors on the market. but we're here to prevent conduct which will exclude those rivals in a way which will harm the competitive process and ultimately sort of the consumers. So a recognition that competition on the merits will sometimes lead to departure of these less efficient competitors. One point which is becoming increasingly important in monopolization and dominance cases is just to make the point that dominance and abuse and effect can all occur in the same market, but they can sometimes occur in different markets. And the concern is that that the dominant firm is somehow leveraging its market power from one market to another. So leveraging can be offensive where it's designed to try and enhance the dominant firm's market power in a related market, could be downstream, neighboring, or complementary, or defensive where it's designed to protect or to try and prevent firm from growing in another market where they might actually challenge its position in and thereby be able to challenge its position in the dominated market. So the EU case law makes it clear that leveraging in itself is not automatically prohibited, but there are certain types of practices which may involve some leveraging, which may constitute an abuse, and we'll look at some examples of that at the moment. So I think we've got fairly similar ideas of what exclusionary conduct is and what it is we're trying to prohibit and to distinguish from competition on the merits. But I think where we do see some difference in the development of legal tests to try and identify abusive conduct and distinguish it from competition on the merits. And I think particularly since the judgment in Brook Group and cases like Trinco, we see a more sort of skeptical stance towards claims of monopolization emerging in the US case law, quite concerned about false positives wrongly condemning aggressive competition by firms, especially aggressive pricing practices, or making firms sort of share their facilities or products with rivals. And I think this is where we see a bit of a point of departure, and the EU courts haven't imposed such demanding standards to prove an abuse as their US counterparts have. And there is a debate about whether or not the standards that they've imposed are good enough, are high enough, or onerous enough, or whether they're too onerous. But I think if we have a look at some of the case law and some examples, we'll see how those might actually differ. And actually, for a while, we did have in place some rebuttable, some presumptions that certain types of conduct are abusive. And although in earlier case law, those presumptions were applied very strictly and difficult to rebut, more recent case law has made it clear that there shouldn't be too hard presumptions of illegality in the context of 102, and that those presumptions should be rebuttable. So, for example, and I think you've had some discussion on the Sherman Act and Section 2 of the Sherman Act on predatory pricing. So, in the US, in Brook Group, the court said that not only if a claimant wants to make out a predatory pricing claim, which is essentially a claim that the dominant firm is lowering prices when it sees a new rival threatening its position, in order to try and eliminate or discipline that rival. And that once that rival has been eliminated or disciplined, they'll then be free to sort of raise their prices again to sort of super competitive prices. And in Brook Group, the Supreme Court said, well, we need to be very careful about low pricing. Generally, low pricing is good for consumers. In the predatory sort of strategy, it's only bad if they succeed in driving the firm out and can then recoup later. So for a claimant to win on that kind of case, they need to show not only are they pricing below some measure of cost, but they're able to establish that there's a reasonable prospect or a dangerous probability that the dominant firm or the monopolist will be able to recoup those losses it made through higher pricing at the end of the predatory siege. And the test in the EU is not as strict as that. And in fact, the Court of Justice said, if you are pricing below your average variable costs, if you're not it doesn't really actually make any sense for you to be producing those products at all. So if you're dominant, we will just apply a presumption that that is designed, unless you can come up with an explanation, that is designed to exclude sort of equally efficient rivals and to exclude them from the market. But also, even if you're pricing above your average variable cost, if you're not covering your total costs, that could be shown to be abusive if the claimant can establish that it's all part of a plan to eliminate a rival. So, and the court does not require the claimant, in addition, to show that the dominant firm is likely to be able to recoup the losses in the long run. Rather, that tends to be assumed that if the predatory strategy is going to work, that's what's going to happen. And as I understand it, in the US, that recoupment requirement in Brook Group actually makes it quite difficult in practice for a claimant to make out a predatory pricing claim. And so it's not such a high bar in the EU to establish predatory pricing. I think we also see a difference in the area of refusal to deal. In Trinco, the Supreme Court seemed fairly reluctant to interfere with a dominant firm's right to choose their trading partners for a variety of reasons. But in the main case in the EU is a case called Oscar Bronner, and the court says, well, yeah, we are concerned about forcing dominant firms to share their facilities. That might have an impact on innovation for both the dominant firm. It interferes with their right to choose their trading partners. But in certain circumstances, we think that it can be problematic, and in particularly where access to a primary market is indispensable for a rival to compete in a secondary market, then a refusal to deal could eliminate effective competition in that secondary market. So essentially, where you can show that access is indispensable, then an abuse may be made out. Now, that's quite a high bar, but not as high as that was imposed in Trinco. And we are now seeing a number of cases which don't involve a right to deal, a refusal to deal, but where a dominant firm has something which it's and it's competing with its rivals, perhaps in downstream or secondary markets, but perhaps on terms and conditions which is making it more difficult for the rival to compete in that downstream market. And one of the issues that has been arising in those cases is, well, do we just treat this a bit like a refusal to deal? Can it only be abusive if you can show access to that upstream product is indispensable, and most of the case law subsequent and dealing with other types of abuse, and I'm going to talk about self-referencing in a minute, says, well, no, they're different types of abuse, and you don't have to show indispensability, although in many of the cases on the facts that arguably the products have been indispensable, but we'll come back to that. So 2 examples of conduct which have been which are held to be presumptively abusive are exclusivity contracts or loyalty rebates and tie-in. So exclusivity contracts are contracts where the dominant firm says, I will supply you, but only on condition that you don't purchase from my rivals. So the contract specifically prohibits them from purchasing from rivals. Or you can achieve exclusivity perhaps in different ways through rebates, saying I will give you a 20% rebate on all the products you buy from me, but only if you purchase exclusively from me. So the orthodox approach laid down in the early cases said that this conduct was just simply abusive. It wasn't allowed. And this resulted in quite a different treatment to exclusivity contracts and rebates under 102 to under 101. And in an important judgment of the Court of Justice in a case called Intel, the Court of Justice nuanced its approach, and it said, well, yeah, there is a presumption this conduct is abusive, but it is always possible for the dominant firm to come forward and to establish that to plead that the conduct isn't capable of foreclosing rivals, perhaps because the exclusivity contract only applies to one customer and there are still numerous other customers that the rival's free to deal with. So they could kind of establish that that the conduct isn't capable of restricting competition, and where they do that, then the claimant then has to establish capacity to foreclose. So this judgment is very important for clarifying that presumption, that rule of illegality is not a hard rule, it's just a presumption. And I think we can say there's a similar approach to tying. So although the court recognizes that these contracts can be risky and make it difficult for rivals to compete, you do actually in certain need to look at the market more closely in most circumstances to see the kind of relevant markets and the number of contracts which are tied, etc. And I think we can see a similar development in relation to the law governing tying. So that is where a dominant firm only sells a tying product to a customer on condition that they also purchase a tied product from them. And the concern here is that tying practice might distort competition in the tied product market, or might be designed to protect the dominant firm's position in the tying market. So although the earlier cases suggest a very strict approach to tying, it would now, it's not clear, there's no specific case on this yet, but it's arguable post Intel that this should also suggest a rebuttable presumption of capacity to foreclose competition in the tied product market. And of course, it all becomes a bit more complicated when you're talking about sort of bundled products and technical tie-in where two products are sold together and integrated. So Microsoft sells its operating system with a media player already installed onto it. Is that tie-in? Are there two separate products, or is there one? So the framework that's applied in these types of cases is a sort of analysis. Have you got two separate product markets? Is the undertaking dominant in the tie-in product market? Is there actually a tie? Has the customer got a choice? And how is that tie-in contract going to impact? Will it foreclose competition and restrict in that tied or in the tie-in market? So a more kind of robust effects base approach. And then in some of the more recent cases that the Commission has been looking at, it's been developing some new theories of harm. And one of the new ones that it's been particularly looking at is a theory of harm, which is referred to as self-preferencing. So where a dominant firm is preferring its own services in the downstream market to that of its rivals. So in Google Shopping, the theory is that through its search algorithm, it was favoring its own comparison shopping services by designing the algorithm so it ranked its own comparison shopping services higher than those of rivals, and the rivals ones could only be found on page 4 of the Google search results, which nobody ever goes down to. And that theory of self-preferencing has now been upheld by the General Court, and I think that case is now on its way and on appeal to the Court of Justice. So as I mentioned, one of the questions that arose in this case is, as well, is this just really a bit like a refusal to deal? And if there is, then we should be applying the Oscar-Bronner criteria, and this should only be abusive if Google's search function is effectively an essential facility. And neither the Commission or the General Court agreed with that argument, but I think they came pretty close to saying that the search function was akin to an essential facility in that case. I think when we look at some of the newer cases now which are occurring in the digital economy, many of the theories of harms are raising either self-preferencing or sort of tying or exclusivity practices, which are kind of have been argued to prevent firms from competing in sort of complementary or downstream markets where they need access to a facility that the dominant firm has. So there's a number of cases going on against Google, which I've listed here. The AdTech case is still going on. As I mentioned, the Commission recently sent out a statement of objections. In all of the other Google cases, the Commission issued fines and cease and desist orders. There has been a lot of discussion about whether or not these decisions have really led to changes of behavior, which are making it easier for their rivals to compete. There's some concern that comparison shopping services are now finding it even harder to compete following the change of behavior of Google. But one of the threats that the Commission has made in the AdTech statement of objection is that if it does find an abuse, that it's difficult to see what behavioural remedies might be there available to solve the problem, and that there might need to be a structural solution, some kind of mandatory divest because there are so many inherent conflicts of interest involved when you're competing on all different sides of the market. So there's a few more big tech cases there. Right, we're nearly at 6 o'clock, so I'm going to deal with the merger reg very briefly, and then I'll just say a few words on the DMA, and then we feel free to ask some questions. So in terms of the merger regulation, I've introduced this. This applies to mergers which are defined as concentrations in the merger regulation, which have an EU dimension. And broadly, that depends on the merging firms hitting certain kind of worldwide and EU-wide turnover thresholds, which are relatively high. If the EU merger regulation doesn't apply, that doesn't mean that the merger just doesn't get reviewed. It could possibly be reviewed at the national level. It just doesn't have an EU dimension, but it could perhaps be reviewed in France or Germany or Poland or Romania, or any of the other member states. And the substantive test in the merger regulation, I think is fairly similar, although phrased differently, to the substantial listening competition test set out in the US statute, and in fact in the UK statute. It refers to concentrations which would significantly impede effective competition in the common market and the internal market. And as in many other jurisdictions, a transaction could significantly impede effective competition because it brings together two competing rivals, or it has vertical or even possibly conglomerate effects. But the main theories of harm that are used in the EU are very similar to those set out at least in the current US guidelines, which I know are under review, the horizontal merger guidelines, which is looking for sort of mergers which are likely to allow the post-merger, the merged entity to increase prices, either itself unilateral effects, or through coordinated conduct with other remaining firms on the market, so coordinated effect. So quite similar framework of analysis in the EU and US. Sorry, that's a very little picture of how procedurally mergers are looked at. So merger debates, which have been going on in the European Union, are mainly centered around the question of whether it's a similar debate that you're having in the US, are markets becoming too or more concentrated, and too concentrated, and have we got too many firms now with entrenched market power? And if so, is merger control partly to blame for that? We haven't been applying it vigorously enough. Particularly, one of the concerns is that certainly in the digital economy, although these markets have particular features which make them prone to tipping, etc., that actually some of the market position might have been as a result of the large number of acquisitions that some of the firms have made in the last sort of 15 years or so. And I think one of the concerns is that the merger regulation itself might not necessarily reach jurisdictionally all problematic mergers, because the jurisdictional threshold is based on turnover. So where you've got a firm acquiring a new startup which doesn't have any turnover, then the EU merger control thresholds won't be triggered. So there's been a debate, do we need different jurisdictional thresholds? And actually, the European Commission's view is, well, no, because we will end up drawing in far too many unproblematic mergers and creating too much red tape for firms. We need more flexible solutions. So the Commission has been thinking of sort of novel ways and more flexible solutions to ensure that it has got jurisdiction, at least in the future, over these types of transactions. And then a second related issue is, even if the Commission does have jurisdiction and is scrutinizing merger, I mean, can you really, using a prospective analysis and trying to work out whether the merger would lead to a situation where there's a significant impediment to effective competition, you know, this task, particularly within very tight time frameworks prescribed by the merger regulation, make it quite difficult for them to conduct that review and prohibit mergers. So there's a discussion, and a similar discussion that's going on in the US about what the standard should be, whether it's too high. I mean, should you even reverse the burden of proof in certain situations? I mean, that's not the case in the European Union. The burden is certainly on the Commission to show that the merger will significantly impede effective competition. It's the burden is only on the parties to demonstrate offsetting efficiencies. But a debate is, you know, how you assess impact, not so much just on future pricing, but on how merger is going to impact on innovation and dynamic competition. And particularly when you're dealing with a startup, it's very hard to look down the long lens and see how that competitor might develop and how it might threaten the dominant firm's position. And really a debate, you know, has there been under enforcement with respect to certain types of mergers? And I think that all then kind of leads on to the DMA, the Digital Market Act. So I think around the world, there's been numerous policy documents and discussions and debate about some of the problems that are emerging in the digital economy because of the competitive dynamics of those particular markets, and in certain circumstances, concerns about the conduct of the digital platforms. And we've talked about some of the cases that the Commission has been bringing under Article 102, where it is really concerned about allegedly dominant firms tying or engaging in practices which prefers their own rival services or products, or is designed to sort of exclude and tie customers into purchasing from them. So numerous policy reports discussing what needs to be done. Should you be trying to unwind past mergers that have happened, or kind of breaking up these platforms? Should they be subject to codes of conduct? Should we be using competition law more aggressively to prevent mergers and to prevent exclusionary conduct, or do you actually need a new regulatory regime to, instead of looking back at post conduct, to sort of ex-ante stop them from engaging in certain conduct? And we'll see, we've seen so far that there has been some concern as to whether or not merger control rules have been effective to counter the growth of firms through acquisitions. We've also seen that the Commission has applied 102 quite vigorously and is using them to deal with what they consider to be abusive conduct in this space. But these are very difficult cases. They have very complex issues of market definition that we were talking about earlier. A market power, they're very complex cases, and then they have involved complex development of the case law and new theories of harm, which are now having to be tested before the courts. There's also some concern about speed. So I just thought a good example about how long these processes take was the proceedings which I mentioned against Intel. The statement of objections in that case was published in 2007. The final decision was adopted in 2009. It reached the General Court in 2014, went on appeal to the Court of Justice, and it was decided in 2017, who then sent the case back to the General Court because they said they'd applied the wrong legal test. The General Court in 2022 decided that actually the Commission hadn't established that there was abuse of the dominant position and annulled parts of the decision, and that is still on appeal now before the Court of Justice. So that was a case where the statement of objections was in 2007. So there is a question of whether or not these cases can be quick enough to deal with markets which are developing and changing very quickly. How effective have some of the interventions and the remedies been? These are also sort of individual rather than market-wide solutions. There has been a kind of a growing view, perhaps, that these are not optimally calibrated or sufficiently nimble to deal with all of the problems. So in the EU, the legislator has moved forward through legislative proposals proposed by the European Commission and adopted a new Digital Markets Act regulation. 2022-1925 was still in the early stages, so it's not been applied yet. But essentially, this is designed to regulate the activities of so-called gatekeepers that provide core platform services which are defined in the regulation itself. So they don't need to be dominant. And the aim, rather than trying to rectify past abuses, is to try and keep markets open, contestable, and fair, where in a sector where you do have a number of these gatekeepers present, which rivals need access to be able to offer their goods and services. So this and the act is going to be enforced by the European Commission, and there will be consequences for infringing it. So it's an ex-ante regulatory framework, and it's distinct from, but complementary to Articles 101 and 102. So the Commission is saying very clearly that doesn't mean we're going to stop applying 102, where we think there has been abuse of a dominant position. But I think when you look at some of the obligations that are set out in the DMA, they seem to be, some of them at least, to have been very much influenced by some of the past 102 cases and the kinds of problematic conduct that the Commission was looking at here. So it's a complex and long regulation, but essentially it's going to work like this. We're going through a designation process now, where at the end of that, certain firms will be designated as gatekeepers. Once you're a gatekeeper, like being a dominant position, that is not outlawed as such, but these gatekeepers will have a duty to ensure and demonstrate compliance with the DMA. And designation triggers a binding set of obligations which they need to, and restrictions which they need to comply with. And these restrictions or obligations are really designed to try and make sure that the market remains contestable and fair. So with very, very limited exceptions, this is a one-size-fits-all approach. Every digital Every gatekeeper needs to comply with the same obligations, whatever their business is. It's not an effects-based approach, so it's not like in Google or in the tying cases, where the self-preferencing cases where the commission has to demonstrate the capacity to foreclose in the market and likely anti-competitive effects. It's just prohibited. So no need to establish capacity to foreclose, no defenses either, no justification for the conduct. And to also to try and deal with that possible kind of jurisdictional gap in relation to mergers, all gatekeepers will now have an obligation to inform the commission about any intended mergers it intends to carry out. So I think that was all I wanted to say. My whistle-stop tour of EU competition law and the last word on the DMA, which is a whole different, not competition, regulation, and a whole different topic in itself. But I hope that gave you a flavor of our laws and how where they coincide and depart from the approach in the US. It's very broad, overarching view. But
Professor, thank you for the very comprehensive and interesting presentation. We very much appreciate your prep time as well as your time this evening. Are there questions from commissioners? Commissioner Simpson? You were leaning forward. Do you have a question?
No, I was gonna say the only thing, the one thing that's jumped out at me, and it's not that relevant to our overall goal, is the enforcement process of the commission that does both the investigatory, indictment, and adjudication, and the only appeal is to the court, is incredibly parallel to my other commission assignment that I have on a California's Commission on Judicial Performance, where that commission investigates judicial misconduct as well as does the adjudication, and it's almost an identical process. So that was something that jumped out at me.
Professor, on one of your slides, you had a bullet about retroactive unwinding of a merger if it turns out that the merger ended up producing anti-competitive effects. Are there examples of the use of that potential remedy?
Well, not many, because the general scheme of the merger regulation is that you have to pre-notify mergers and you're not allowed to complete them until you get clearance. So in theory, the merger shouldn't have been completed before you get authorization from the commission. There are some certain circumstances where the case might end up with the commission where the merger has already been completed, perhaps because originally they didn't meet the thresholds, so the parties didn't need to notify it, but a member state asked the commission to look at it and referred the merger to them. And there is a case involving two Finnish companies where that happened, and where they, I'm just, Kesko Tuko it's called, I think, but I can check that, where the parties completed the merger, the authorities referred it to the European Commission, which prohibited the mergers, and then ordered it to be rewound. And I think the power is under Article 8 of the EU merger regulation. So it can be used, but it rarely needs to be, because the general rule is you can't complete the merger until you get clearance. So it's predicated on the idea that you have to try to stop needing to unscramble the eggs. You stop them being scrambled until you get the clearance.
Thank you. Are there other questions from any commissioner or staff member?
Commissioner,
Commissioner King.
Hi, thank you for your presentation. I was most curious about the DMA and how you see your countries used to be, and the European Union seems to be much more advanced in that area of antitrust law than we are. I'm wondering if you have any thoughts. I know you may not focus on American efforts, but as I understand it, America tried to do something like the DMA with the American Innovation and Choice Online Act, which failed to pass Congress. And so one of our problems on the commission here is, as much as we like to write antitrust law in a certain way, we have to be realistic about what can actually pass. And so do you have any thoughts as to the differences between the AICOA and the DMA, and why it couldn't pass Congress, assuming you've looked at that?
Well, that's a really difficult question. I mean, I don't know enough about, I do, and I think that bill may have, I may have come across that, but they might be trying to reintroduce it. I mean, it might be to do with the legislative process itself and getting enough support for it, but it could also be the way that it's drafted as well. And, you know, the way that it's drafted, who gets targeted by it. So I would imagine, you know, it may be factors such as that as well. And obviously, I think the Commission's the EU solution is relatively controversial in the sense that there are these very complicated obligations which are apply across the board to all these quite diverse. We don't know who the gatekeepers are yet, but we will know within the next few months, and without any defences. But I know that sort of in the UK, for example, they are trying. I mean, there is a bill going through, just being introduced into the House of Commons at the moment, although you probably know our Parliament's all been quite busy recently with other things. But they are taking a slightly different approach to who the bill is going to be targeted at. And also they want to introduce more individualistic approach with different codes of conduct which apply to the different firms targeted, and with even possibly with some defenses. But the more complex you make it, the more hiccups you're going to get along the way, and more challenges. And I guess that maybe the more difficult it is for it to apply. So I would imagine it's a combination of how the legislative process works itself, but also, you know, trying to make everybody feel comfortable with who it's targeting and what is targeted, and whether or not you think, you know, that could end up sort of hampering competition in some ways, or whether it's going to be too complicated to be enforced, etc.
Okay, well, thank you. As a follow-up question, as I said, the DMA seems to be at least an effort to go in a direction that American law hasn't really gone into yet. Are there any other areas or focuses that you think the Commission should look at as being a priority for reform?
Apart from in digital, you mean?
Yeah, within digital or apart from digital, you know, from your more European vantage point, what are the priority topics or subjects that you think most need looking at or reform?
I think, yeah, I mean, I think most the focus in EU on sort of the limits has been on digital economy. I mean, there are some other areas where they've seen problems and you introduce sort of laws to deal with it, sort of roaming charges or something. But I would think one area of difficulty is particularly in relation to 102 is, you know, what you do at the end of the process and the question of remedies. And, you know, these are long and difficult processes, and how easy is it to ensure that your intervention matters in a meaningful way. And that's, but that's really a more case specific and case by case approach, and something for a competition authority, I suppose, to think about at the start of an investigation, that if we do end up finding abuse, what can we do about it to make the markets better? Because I imagine this is an area where the sanctions, they're very significant, but how effective they're likely to be in deterring conduct, it might be questionable. And I guess merger control is also another area perhaps to think about. I mean, I know that there are very different views in the literature about how much of a problem this is, and kind of debating whether or not merger control's been too lax or whether it's been okay, but that might be also something to think about and to review as to the burden standard of proof in these cases and in particular types of cases.
Thank you.
Thank you, Professor. Commissioner Kubas, did you have a question? Anyone else with a question for the professor while we have her?
And I'm happy, if you think of questions later, I'm happy to, please, Brian's got my email, just send me a message and I can try and point you to relevant literature and answers.
Thank you. Thank you again, Professor Jones, for joining us. Have a good rest of your evening.
Thank you very much for inviting me, and yes, enjoy the rest of your day. So
Thank you.
Stop sharing and now work out how to leave. Thank you, but goodbye. Bye.
Thank you,
Bye-bye.
Professor. I think we're ready.
Okay, welcome. As a result of the closed session that was held, there has been an offer that will be extended to an applicant for the position of Executive Director of the California Law Revision Commission.
And that, I think, concludes the meeting. You want to gavel us out?
Adjourned?
Yay. Thank you.
Great job, everybody, on the interview process. Very excited.
Yeah.
Bye.
Take
See you
care.
all in August. Bye.
August.
All right.